Welcome, everybody. Thank you for making time for the program committee, and for those of you who are new, for agreeing to be on the program committee. As the new chair of the commission, this is also my first time on the program committee. And one of the things I'd like to talk about today, after we discuss some of the specific proposals, are what criteria we're going to use to decide what projects we're going to get, because we are getting a lot of requests, and I'm a little concerned about bandwidth and making sure that we have enough, at the very least, enough commissioners to properly staff these groups along with the other people that we get together. But because we have some people who are here ready to present, we're going to start with that. So we have Chana here from the Judiciary Committee, who's going to talk about the Custodial Parent Project. Thanks for being here.
Thank you for having me. Again, I'm Chana Newell. I'm counsel for the Judiciary Committees in the Oregon Legislature. I'm here to talk with you about the Law Commission undertaking a project related to Senate Bill 736 from the 2019 session. I spoke to some of you in October of last year at a commission meeting about this proposal. And so I'm going to try to briefly recap the proposal, how we got there, and what the proposed solution is. So the proposal is to take language out of the family law chapters of the ORS that could be seen as loaded or kind of winner-take-all type language, such as custody, parents with custody, joint custody, and replacing them with more neutral words, and to allocate different provisions of custody to different parents as they agree or as the court decides. So back in 2015, we had a small group of individuals come to the legislature, and they explained to us that they've had instances where terms like custodial parent, I'm the parent with full custody, create an all or nothing situation for folks. So that term causes otherwise reasonable people to suddenly go get their arms and really behave badly with each other, and creates a situation where it's all or nothing. You either are the custodial parent or you are not the custodial parent. They tend to use it as a club against each other. Likewise, so a work group was formed, and we started delving into that, and it became immediately clear that there was a lot of confusion about the difference between custody and parenting time. So we did some work on trying to clarify those two things, and we really started developing an understanding of just how charged that language can be for particular people. Initially, the work group proposed something along the lines of what Illinois did a couple of years ago. And Illinois just wholesale took out the term custodial parent, and they changed it to an allocation of parental decision-making standard. So it was kind of a wordy change, but it would be the parent who's been allocated the decision-making on XYZ, or the parent who's been allocated decision-making on ABC. We proposed that to Legislative Council, and they said, no, this is too much for us to do in a session. Look at it a little bit more, narrow it down, tell us exactly what you want to do. And in Illinois, this took 10 years to develop. So we thought, well, even though we have a template here, we haven't had those full discussions about the ramifications of the change and what they actually mean. So our second proposal was Senate Bill 736, and it defines custody as decision-making. And it allows the allocation of decision-making authority to one, both, or the other parent. So for example, you could have one parent who's allocated decision-making on the child's education, while the other parent is allocated all other decision-making. So it would be either by agreement of the parties or by the court. So that's what Senate Bill 736 did. In hearing on that, a lot of unintended consequences started popping up. And especially Judge Maureen McKnight said, can we take another pause on this and start looking at exactly what the consequences of this change mean, in some highly specific areas. So we have a list of where these changes appear and where we would need a group of very thoughtful people to talk it out and to work through that. And that's essentially what we're bringing to you. Can we have a group of expert stakeholders who are willing to look through those changes and explore the unintended consequences? These areas are largely in child support, dependency and delinquency, and other rights of parents. So that's what we're after. If you have any questions, I'll do my best to answer them.
I apologize for my lateness.
For those of you on the phone, we've just had Judge Egan join us as well. Would you say, Chana, that all of the stakeholders agree that this is the kind of change that needs to happen? It's just a question of how?
Not necessarily, no. There was a group of stakeholders who were very firm on removing the word custody completely. They thought that that term, even if it were defined, it's currently undefined in the ORS, even defining it wouldn't be enough. The word itself is just too loaded. The issue with that is that by taking that word out wholesale, the ripple effect across the entire code is just massive. And so we couldn't quite take that step.
So part of the project would probably be determining, instead of saying this project is that we're going to replace this definition of custody and parenting time, the issue would be we have this problem of people fighting and that this word custody is causing problems. What should we do about it? We might not even...
Well, I might hesitate to say that because the work group and the legislature, when they put 736 together, said we would prefer to keep the term custody. We would prefer to have this here and define it in a way that tells you, rather than opening that discussion again into whether it should be there or not. So I don't think the legislature's intent in asking you to look at this is to look at the basic problem there. I think that it is safe to say that when they discussed this in committee and in the work group, the majority of participants wanted to define it and keep the term, but there was a minority of participants who wanted to get rid of it completely. So I don't want to say that it was, unanimity to go the 736 route, but it definitely was a majority of the folks participating, and that was the intention of the legislation, was to keep it. Not
to be too pushing on this, but I'm concerned about making sure that we're defining the scope of the project. So is the scope of the project to see what happens when we define the word custody, or is it to make a recommendation on which of those two routes we should take? I don't think it is necessarily either. So the project, 736, offers a definition. We're asking the Law Commission to examine the consequences of that definition. So where that term appears in other statutes, what does that mean? What are the implications? And is there a recommendation for how to handle the implications? I think I put in here an example that Judge McKnight gave, and that was, under this new definition, there could be a prohibition on a parent who's been found to abuse the other parent from having any parenting time with the child, just by the way that the statutes interplay, regardless of whether it would be in the best interest of the child to have parenting time. So that could be an unintended consequence. We didn't intend in this work group or in the legislation to make any statement about what is in the best interest of the child in that particular circumstance. So we would ask this group of experts to look at that and walk through the different scenarios and recommend a change that would be in line with what our current practice is. Okay, so the idea is how to keep the general current practice while changing the definition.
Yes. We don't want unintended consequences that are disruptive. So if there's a minor, I think it would be safe to say if there was a minor unintended consequence that the group felt was a net positive, we'd be happy to hear that recommendation.
Mhm.
But we're not seeking recommendations for changing policies in other places. But 736 as written does make changes that are not intended. So we want help finding those and talking through it with experts.
So it's a little bit of a different project than what we would normally take on, because you're not actually asking us to end up with a bill. You're asking us to end up with a report.
I think that there's a good chance that your report would end up with a revised version of 736, because you would be recommending language based on 736 in order to keep the current practices in place and avoid unintended consequences.
Mhm.
So I do expect it would end up in a bill.
Okay.
Was legislative council, I know they were involved early on, but were they involved in the process of creating 736?
Yes.
They were, okay.
How much of the cross-checking has already been done? Because it seems like that's a big part of this
Huge.
project. It also raises questions for me about how much of that is our task force versus how much of that is really more usually legislative council.
So Legislative Council has provided us a list of potential cross-references and areas that we need to look at. Judge McKnight provided some additional ones as well, and I have all of those and can share them. I initially asked Legislative Council to sit down with me and walk through them so that we could say, okay, you know, when we're talking about 25.280, which is apparently physical custody / custodial parent, I feel like part of my role in the legislature is helping the policymakers decide what to do, and I have a particular hat that I can wear and assist them with that. And Legislative Council and I can walk through these. And they declined to do that because they felt it was a little more policy-heavy than what Legislative Council is comfortable doing. And I am certainly no expert in this field, and so it is not something I can undertake on my own.
It also feels like it's a little bit less policy-heavy than the kind of work we would normally do. And that's a little bit my concern about it, you know, is that my understanding of the typical projects that the commission would take on is that we would be presented with a problem, a policy problem, and be asked to recommend a solution. Whereas here, we're really being presented with a drafting problem and are asked to help work out the solution to the drafting, which I understand what you're saying about Ledge Council, but that seems a little bit more like what they would normally do. Am I missing something there?
Legislative Council's feedback on this was that it was too policy-heavy for them to do. And I think what 736 is a proposed solution that we're asking for help to make sure works properly. And we need a group of experts. And in the past, this has been a really good place to get those experts together.
I wonder what happens if we get the experts in the room and some of them don't agree that this is the right solution. Because I don't think that we can pick our work group, you know, based on having only the people in the room who think that this is the right answer. If that happened, what would be most helpful to the legislature?
I think having a report back on that, you know, just simply saying this couldn't move forward for these reasons, this is a very thorny issue. And ultimately what would happen is that I'd be tasked with getting my own independent group to make it happen. That's what. I think there have been other topics along these lines that have been, this line in particular, but in style that have been just issues that have not resolved, but they've been worthwhile discussions to have.
Why is it more beneficial for you, other than just a workload issue, which I totally understand, why is the commission a better venue for this rather than you convening your own independent group?
Okay, that's a great question. The formality of it and the gravity of it is a great reputation. People appreciate that if this is a law commission project, it is being taken seriously and effort is being put in and folks come to meetings and they do their work and they're invested. People like to put this as, you know, work that they have done. I participated in this law commission group. There's prestige behind it to be able to say, I participated in this, I worked on this, people take it seriously. And it has more authority than I do, dragging people in a couple times a month to sit in a room and walk through issues with.
Susan and Keith, I know you guys are both on the phone and that you've seen, maybe more of these projects than some of the rest of us have. I wonder what your thoughts are.
Well, I think, PK, you've raised the couple of questions. It sounds to me like, from what Legislative Council has said, that some work group, whether it's through the OLC or some other source, needs to go back and take another look. If I'm understanding it correctly, though, that raises a question of if a work group takes another look, they may end up with a different solution. And maybe that's okay. Maybe it would be good to get more input and think about this with the goal of working through what was decided. I know with probate code, sometimes we would go back in a subsequent year to an issue that we had thought was resolved, and we would go back and revisit it. And at some point, it has to end. But sometimes it's good to go back and look at the issue again, and with everybody in the room, maybe with the goal of this is where we agreed. Unless there's a really good reason to change the direction, let's just figure out the unintended consequences. That does to me seem like it's policy and not LC. So it makes sense that there would need to be a work group of some sort. But I don't know how that is going to play out if people do have different views coming in. It just, from experience with the probate code, we would revisit things multiple times that I thought had been decided, and then we'd end up talking about them again. But in the end, it was okay.
This is Keith. I've got a couple of questions. What time frame are we looking at?
This is Chana. The time frame would ideally be 2021, but if that is too much, then 2023 would be appropriate. And I hesitate there because we will see legislation around these particular issues in 2021, if not for a revision of 736. If that makes sense.
Mm-hmm.
It's a topic that comes every single long session and needs to be addressed. So it's a very consistent issue for us.
So then I've got a question for both Sandy and PK, and that is, given the existing workload of the Oregon Law Commission and the other projects we're working on, is it even feasible for us to tackle this in the next 12 to 14 or so months?
Do you want me to go first?
Yeah, I think it's a good question, Keith, but
I do too. I think a lot of it depends on the willingness of folks who have worked on the previous work groups, especially the folks who are involved in 736, to continue to work and not have to start over. I think, and the other thing, I was actually going to ask as a follow-up to Keith's question, is reading between the lines of what you were saying before about more legislation, about whether or not there would potentially, I know you can't answer this question specifically, be potential buy-in from the members or staff of members of the legislature who might be invested in this issue to participate in the OLC project rather than do something else. Because my biggest concern is I do think if we had a solid group of members who were already together, who knew the issues well, we didn't have to go back and teach people the key issues. That group was at least representative of many sides of the issue, and it sounds like that is true, that it would be more of using the commission to help convene, to provide the seriousness, as you said, and make sure that we have it as a public process, the public record. I think we do have the capacity for a 21 project if those aspects are available. If not, and I think what's also key, buy-in from any parties who might want to put their own alternative out. Because I would be concerned to put in the work that it would take to do a one-year project, which would end up being, and have very little chance of passing. Because I think that part of my job is to ensure that the work that we put in is able to have better than good shot of getting actually adopted. So I guess that's quite a few questions, but.
I will say Senate Bill 736 had bipartisan support.
Okay, good.
It is a committee bill, so looking for a sponsor list, but it doesn't have one because it was a committee bill. So it had bipartisan support. It was generally well received.
Okay.
And when I referred to the minority who wanted to remove custody entirely, it was two folks with real strong views that couldn't be budged. They were not legislators. They were important people at our meetings to remind us of this viewpoint and to work through issues. But I'm not sure that anything short of their goal would have been satisfactory. But there were several people in this group who moved their position and came to really like 736 from a prior position in a different area. So I think that you could get bipartisan legislators to come work on this issue, for sure. That said, the technical nature of this will need to have primarily membership from attorneys, I think. Right now, there's a great scarcity of attorneys in the Oregon legislature. And there are even fewer who practice in family law. So I think that finding the right people who can provide, legislators who can provide value aside from being legislators, having some sort of helpfulness in this area could be a little difficult, just because we don't have that many.
And
Do you think Judge
if I might, this is Susan Graby with the Oregon State Bar, and I can't, I would like to say that we can try to ensure members from the family law section engage, but Chan is right. It's tough to get legislators, since there's so few, lawyer legislators and legislators who would be interested and engaged on this issue. But we're ready to assist as needed.
And I want to make sure we can find legislators who will participate. Like I am confident that Senator Thatcher would love to participate in this. She would bring a helpful perspective, but she's not an attorney. So if you're looking for attorney legislators, that's going to be difficult to dial in.
So one follow-up then. If there's a work group that is very familiar with the background of SB 736, why not just toss it back to the initial work group, since they're the experts on the bill and the ramifications of the bill?
That's a great question, and that may be what happens if OLC doesn't take it up. That group met for 4 years to develop 736 and had a lot of contention at times. And I think there was a little bit of exhaustion from the group to continue rehashing this issue, especially when we were delivered a product that wasn't fully finished, and feeling like this group, as it currently was composed, couldn't finish it, that we needed more help. We needed an outside group. We needed the gravity of the situation in order to pull it all together in its final form. I suspect that if the Law Commission takes it up, that there will be some significant overlap between those groups, because there are people who do want to continue to participate in the discussion, who have the expertise to, but it can't just be them. It has to be other folks as well.
This is Jim Egan for the folks on the phone. I'm asking just to kind of wrap my head around everything. What I hear you saying is that the 736 work group ended up being a hung jury, and you want to know whether you need to reconvene another kind of jury to come back and inform the first.
Not necessarily, Judge. I think you had near unanimity on 736. You had a lot of support for 736. There were multiple other issues that work group worked through. In the very early days of that work group, there was a lot of contention about what we were going to work on and what we were not going to work on.
Illinois' work model, or Illinois model, and getting rid of the word custody versus not getting rid of the word custody. Is Is that still kind of the big issue?
No, the other issue that I haven't brought up at all that this work group worked on was equal parenting time as a default setting.
Oh, okay, right.
Okay, so that was extraordinarily contentious
Well, I'll bet.
and caused a fairly large break within the group. And so that was set aside eventually, and we moved forward with 736 because most folks could really get on board with that. But because of that dynamic, the group had a lot of meetings that felt really contentious, and a lot of folks just felt like they were needing to withdraw a little bit. And I think with a fresh start with other folks who have professional backgrounds, who are in an environment that is very serious and very formal, it will go a lot further than me convening the same people in a similar environment.
So what I hear you saying now is, and not that you said anything differently before, but what I am now comprehending is that perhaps one of the results that this group could come back with is, we have reviewed your work and you're going in the right direction. Another might be, we have reviewed your work and you need to take another look at this Illinois model and get rid of the word custody. Or we have reviewed that, we think there are these tweaks, but that, you know, things like the custody statute's relationship to Oregon Revised Statute 656, workers' comp, my thing, or 654, work safety, which has, believe it or not, the word custody comes up in 654, or the Administrative Procedures Act, 183, or any number of different things. We need to retain that word, you're doing fine, move in that direction.
We're hoping for option C.
With respect to the prior provisions or contingencies on the former work group, should the commission have any concerns about whether we would be viewed as just kind of a new place for some, but not all of the members to participate, and then kind of not eliminating some dissent by excluding people? I think that would be a concern that the commission would have. Is that, how are we going to avoid that?
So I have addressed this with the work group, and I think it was on the public record when this was up for hearing, that when the Law Commission undertakes this, it will be a very formal setting, and it will be, it is an open meeting, and folks who have interest can express that interest, and they can come to meetings. Whether they would be seated at the table to speak at length about their views about equal parenting time, where it is not an appropriate setting, you know, that would be something that would be under the commission's control. And so how that might be perceived would depend on how it's handled, for one. But the work group is aware that it has been sent to this body to look at, and that it is a more formal, deliberative process, and that there will be a large stakeholder group, and that they can contact as an interested party or be invited to join. That would be the commission's decision on who the actual parties in the work group are.
Everyone, this is Commissioner Jayapal. I'm so sorry to interrupt this conversation, but I am going to have to leave in about 10 minutes. We thought the Uniform Partition of Heirs Property Act was going to be at the top of the agenda. So if there's anything that I can add or answer, I would love to be able to do it now. Again, sorry to interrupt the other conversation.
Commissioner, thank you for
chiming in. I apologize for the late change in the agenda.
Tana, do you have another couple minutes to hang on? So we'll do a little bit of a switcheroo here, folks, just changing gears. The project that was initially on the beginning of the agenda was about the Uniform Partition of Heirs Property Act, and we are going to talk about that in some detail a little bit later on, but I do want to thank Commissioner Jayapal for being on the phone here and give you an opportunity, Commissioner, to maybe explain to the group, what we talked about in our phone call a month or so ago about what this issue is and why it's important to your constituents, if you don't mind.
Absolutely, I'd love to. So yeah, it's Sushila Jayapal, and I'm on the Multnomah County Commission, and I represent North and Northeast Portland. which, for those of you who know Portland, know that it's been the historic home of the Black community as well as many of our other communities of color, and also has been sort of ground zero for a really rapid and severe process of displacement that's driving families out. And many of the families who've been driven out have owned their property for many years. The reasons for the displacement are complicated and systemic, but one of the things that I've heard in the last year, I've been in office for just a year, one of the things I've heard repeatedly is the problem of what happens when a property that's been owned for a long time has passed intestate, passes to multiple heirs, and partition occurs, and the family loses the property. And so as I started to hear about this, to be honest, I Googled the issue and came up with a number of articles about the Uniform Partition of Heirs Property Act. I think it's 10 or 11 other states that have adopted it, create some guardrails and some protections for these families. And that was really what I brought to the commission. I am concerned even more recently that this process is going to accelerate as a result of HB 2001 and movements in the city of Portland around the state to increase density. And so I think that what we've seen happen is going to continue to happen. And I think it's really important that we do whatever we can to keep the folks who are subject to this form of displacement where they are. To me, it looked like a pretty simple fix. I'm sure those of you who've dug into it more know more about the details, but that's really why I brought it to you.
And just, thank you, Commissioner. Just to let you know, Professor Susan Gary, who actually wrote the proposal that we have, will be available to discuss more. Also, Professor Lisa Bates from Portland State, I know, will also be available on our call at 1 o'clock.
Great. Anything else I can tell you? Questions I can answer? And my staffer, Angela Donnelly, is here as well, and she can stay on the call.
Commissioner, thank you so very much for bringing this project to our attention, even though it's come here several different ways. That lets us know the importance of the issue, and we really appreciate your support.
Thank you for your work. Appreciate it.
Anything further for the Commissioner? Okay. Thank you so much for joining us, and Angela, we'll look forward to continuing to have you on the call.
Thank you.
So moving back to the issue of the custodial parent piece. I guess one of the things that, maybe you've said this already, Jana, and I've just missed it, but you said there were some folks who really just wanted to abolish the term custody altogether rather than redefining it. And what was their reason for wanting to do that?
They felt the term custody, no matter how you defined it, would always be a loaded word.
Mm-hmm.
And would always be a sword or a club that one parent could use over the other.
And are those folks coming from any particular constituency or stakeholder group?
I think they are generally folks who have had a bad experience with the court system and have ended up being the non-custodial parent, and in some cases related to somebody who was a non-custodial parent, and just feeling like that there was injustice there.
Jana, a question. You had said as part of the proposal that potentially Senator Prasonsky would be willing to chair. I know he's not here today, and he was unable to make it. He's actually a part of this committee. But have you had discussions with him about specifically his willingness to? The reason I ask is this is because of the potential for folks to come to a public meeting and want to get off track, potentially, and especially from the history in the work group, having a clear separation between members of the work group and interested parties, and ensuring that we create a professional environment and also move forward. This would be a chair-intensive project. There's no question about that. And I'm just curious, usually the tradition of the commission is that, not always, but the tradition is that the chair is a member of the commission. Senator Prasonsky is a member of the commission. I'm just curious if you have any further details about that.
I think he would be happy to if his time allows.
Okay.
That's a pretty safe answer. And that he would be because of his vast experience with handling sensitive and complicated issues.
Thank you.
I am concerned about this issue of us taking this up on a year-long time frame and then potentially having the work derailed by another bill. Do you think that there is any assurance that you can give to us, or might be able to at least discuss with the members of the relevant, I guess it's just the Judiciary Committee, about whether or not they would let other projects go forward while our work is continuing?
Generally speaking, when something is under work by the Law Commission, we don't touch it. That's a pretty firm rule that Senator Brzezowski has put in place. It happens with probate. Folks will bring different probate bills and will say, but the Law Commission is working on this, so we're not going to handle this session. So I think that at most, and I'm doing a little crystal ball work here, at most there might be an informational hearing, a public hearing on the proposals that came in the 21 session, but understanding that the Law Commission is doing this work and we're not going to supersede it with this package. We generally don't like to ask you to do work and then
We would appreciate that very much. It's hard to pull these things together. Does anyone else have any other questions for Chana? Anyone on the phone?
I don't, thank you.
Okay.
I don't know if this is as much of a question, but I just want to share my sense of what we're being asked to do so that if that sense isn't accurate, you can correct it for me. It seems like there's been a limited goal, which is to eliminate the term custody from the domestic relations statute, that part of the code. And it's not even to eliminate the term, but to redefine it.
to define it.
To define it. And so that's the end objective, right? And for good reasons, to eliminate or reduce the kind of battling that can go on in domestic relations. That's good, but then we're being asked to figure out what the ramifications of the definition in that chapter have throughout the code. And part of what I think might arise is that there will be discussion when we get to, well, how should we phrase it in this area? There's going to be policy questions that arise in areas from probate to the compensation to juvenile and delinquent dependency. So it seems like there's a lot of things that could come up that could present policy issues for us that are completely separate from the limited objective of this bill. And is that a fair understanding of the request?
Your Honor, that's pretty accurate. Okay. Yep, and I would also say that the one element of it is defining custody, so folks know what it is. That requires looking at the use of custody in these enumerated statutes and making sure that we're not deviating. As I've said in here, we want to be consistent with the policy that's here or here representation. The other part of this is that the bill does allow the allocation of parental decision-making authority in different areas. And so that context has to be applied when looking at the term custody. So there's just a little extra layer on that.
And so if we have a situation where right now, in perhaps statutes dealing with education, that the parent who has the custody is the one who the school releases information to, we would be in the position of having to say, well, if custody is decision-making, and this decision-making can be divided into different parts.
Is it then the parent with decision-making authority for education? Is that the term we need to use to be clear as to what the intention is?
Or is it
either parent who has custodial decision-making authority? However that works out. Those are the sort of things that need to have a robust discussion. That's awesome.
Yeah.
Tell me what you're hoping for at the end.
to have a formal deliberative group work on this so that when this product is delivered to the people of Oregon, it's functional and captures the objectives that we want. Here is absolutely to reduce friction in domestic relations proceedings and to use this approach as a way to affect that.
Okay, well, we've got a lot to talk about.
Okay.
Thank you so much for
Any
coming.
other questions, please let me know.
We sure will.
Thanks, Shannon.
So because we have someone else joining us at 1 o'clock to talk about the Uniform Partition of Heirs Property Act, I think the next item on our agenda is going to be e-wills.
Yeah.
But I want to check in with you, Angela, and make sure that you can hang on that long. Will that work for you?
Yes, that's fine for me.
Wonderful. Thank you so much. Susan, were you going to talk about e-wills?
Yes, I am. Happy to talk about it. So I always have to start with a disclaimer that this is working on a law review article about the problem, and it's something that is coming inevitably. I think a lot of lawyers wish the problem would just go away, and that's not going to happen. So the Uniform Law Commission developed an act for the provisions that would be added to the probate code to indicate when a will that is executed electronically would be valid. Wills usually start in electronic form on a computer, but then are printed and signed after they are completed. And the idea was to look at a situation where the will starts electronically, is executed by the testator and the two witnesses electronically, and remains as an electronic document. The statute, the Act, the Electronic Wills Act, that was developed to address two types of situations. One is someone working without a lawyer at home, probably creating a will and assuming that the person can execute a will effectively online, because so much of our business lives these days it takes place online. So particularly we in the committee, and I should say I was the reporter for the Uniform Law Commission's Electronic Wills Act, so when I say we, it's that drafting committee. The drafting committee talked a lot about millennials, but it's not just millennials. Many of us are used to doing our banking online, signing contracts online, doing all sorts of things online. And there already have been, but there will be increasingly people who assume that they can create an electronic document and sign it and assume that it will be valid, and it may be. It may be valid in Oregon. We have a statute that allows a court to give effect to a will as long as it's in writing, with some leeway as to the execution formalities. But we wanted to create a statute that made it clear that electronic writing was still a writing and wouldn't require someone to go into court. So that's one concern. The other concern, and frankly the reason that the Uniform Law Commission moved ahead more quickly than it might otherwise, is that there are some companies that provide legal services. Willing.com is one of them that I should step back and say they would say that they don't provide legal services, but there's arguments about that. But they provide will preparation services and allow their customers to have access to a will form, fill it out online, and currently what they have to do is to tell their customer, you fill this all out online, now you must print it before your witnesses sign it and you sign it. And what they would like to do is to allow the customer then to log in to a website where witnesses are at the ready and have the will executed online. And then what the company would also like to do is to then store the will for a fee, of course, for the client and have the will be stored kind of as part of their business model. So Willing.com created a bill that has been introduced in a number of states, and in some of the states, the estate planning lawyers, as they saw what was happening, pushed back and changed the bill and came up with a different strategy. But depending on the state, you can see kind of the evidence of the Willing.com bills, and it was clear that was going to continue around the country, that Willing.com was looking for legislators willing to introduce the bills, and that was going to continue to happen. So we had several goals in creating the act. We wanted it to be as clear as possible as to what was valid and what wasn't valid. We didn't want to create a statute that would incorporate a particular business model into the statute. And we also wanted, to the extent possible, simply to follow the existing will execution law of any state that adopted this act. So that's kind of the background of the uniform version of it. I think, and the reason I proposed it for the Oregon Law Commission to consider is I think we are going to see more and more situations where people attempt to use electronic wills, and we need clear guidance on what is valid and what is not. And I think this act will help with that. There are, because of concerns about how this should, what requirements should be there, how much protection should be built into the act. There are parts of the act that are in brackets to indicate whether, that a state should look at that and think about it. Some states are likely, actually 2 of the 4 states that have adopted some version of an Electronic Wills Act require that everybody be in the same room when the will is executed, witnesses, notary, and everybody. And the other 2 have not. People can be, their presence can be obtained electronically. And so it's those kinds of things that a work group would have to think about. I think as groups around the country are looking at this, there are changes that are being made depending on what that group thinks is best for that state. So I would expect a work group to look at all of those issues and think about what would make sense in Oregon. But I think it would be a good project for the Oregon Law Commission. It follows the other probate work that we've been doing recently, and I guess that's a good place to stop, and I can answer questions. Oh, actually, one other thing I wanted to say is that the Oregon Law Commission also has a work group to consider the adoption of the revised Uniform Law on Notarial Acts, RULONA. One of the things that I learned in the process of working on electronic wills is that RULONA provides a great deal of protection for any document that is notarized by a notary that is authorized under the procedures set forth in RULONA. It's a particular type of notarization, remote online notarization, that locks down the document, that provides a lot of protection for the will. One of the concerns, of course, with an electronic will is the concern that somebody's just going to get into a computer and hack the computer and change the will. And particularly with I think in general that's not as much of a concern as some people worry about because of metadata and some other evidence that any electronic document would have. But the type of notarization that RULONA will authorize, the notary would have to be certified to do that. That will really protect the will, and one of our concerns in drafting the eWills Act was protection for the testator, to make sure that the testator's wishes get carried out and to minimize concerns about undue influence and someone taking advantage of a testator. And with that, I will end and be happy to talk more about the Act or answer questions.
Just want a quick reminder. Yes.
Oh, I just wanted to say that I just joined the call. This is Lisa Bates at Portland State University.
Thank you, Professor Bates. We're going to start on your piece of this at probably at about 10 minutes.
Just a quick reminder to members of the commission on the call and those in the room. Our Rulona project actually has a completed bill which the commission approved at the last commission meeting. We weren't able to move forward this session strictly due to the rules around sponsorship during the short session, but that bill is set for a 2021 process and would work in collaboration with the eWills bill. It would be the process that Professor Gary describes is covered in the Rulona bill that we have together, and the Oregon-specific concerns with remote electronic notarization were dealt with through that process. So that another positive piece of this project logistically is we already have a committed group of attorneys in Oregon who have worked on the probate process and now the remote notary process. I can't say whether all of them will continue to move forward to work on this project, but this is a group of attorneys who have shown their commitment over several years, and I'd be very surprised if they would not be willing to, especially when it's based off a uniform law bill, which is carefully constructed at the beginning. I would guess that the majority of those folks would be willing to work on this project as well.
Susan, do you think that this act, this Wills Act, necessarily depends on the legislature already passing the Rulona project bill?
No, it doesn't. And in fact, the way the act is set up, the will itself is valid even if it's not notarized, even if there is no self-proving affidavit that's notarized. The will addresses what does it take to be a valid electronic will. In order for the will to be self-proving, there has to be a self-proving affidavit. That can be notarized under the non-Rulona way of notarizing anything. And that works if everybody's in the same, under the Act, works if everybody's in the same room. The advantage of the Rulona process is that it allows the witnesses to be in some other location or the notary to be in some other location. But it's set up so that it's not dependent on Rulona.
Great. How long do you think it would take to do this project?
I would expect that it could be ready by 2021. I will say that based on what we heard in our discussions as we worked on the uniform version, there will be pushback from some members of the estate planning bar. What has happened in the states that have looked at this is I think the estate planning lawyers have realized that it really is helpful and important to have some form of statute. They may not be happy about it, and they may never use it themselves, although I think actually estate planning lawyers will end up using electronic wills. But I think what has happened is as the lawyers become educated about what this is and what it means and think more about it, they are grudgingly willing to have a statute on it. I'm guessing there will be discussion about why do we need something like this. We've heard that pretty much at every step of the way. But I think we have that conversation. We talk about the protections that are built in for the testator, and then unless the work group would decide to go with something pretty different from the uniform version, which I suppose they could, assuming they are going with the uniform version, I think it would be ready by 2021.
I think probably, if I'm hearing you right, the response to why do we need this now is that these electronic wills are happening and we need to know what to do with them one way or the other, right?
Yes, exactly.
Any other questions on this one?
Any other questions over the phone for this project?
None from me. This is Keith. I think this is a great companion bill for the work that's being done on the e-notary bill or issue, and I think it makes sense to try and address them in parallel.
And just as a note from logistics, I have full confidence this could be a 21 project. Again, the group of folks we have together who are experts on these particular issues, are a particularly committed group. Wayne Shetterly, I think, would be interested in, I've spoken with him, interested in helping to lead this group, as well as we have Professor Gary. So no concerns about creating a bill by the 21 deadline.
So I think I'm going to push our decisions on these to the end of the meeting. So if there are no more thoughts about this one, I think I'm going to move on to the Uniform Partition of Heirs Property Act. Anything else on that one? Okay, so let's move on to this one. And Susan, I believe you were also willing to introduce this issue, and then we'll also hear from, of course, Angela and Lisa Bates.
Yes, happy to. And we got a good preliminary introduction, I think, from the Commissioner about the problem that this is attempting to address. What has happened in other states, this was first noticed in the southeastern states of the United States, and the Uniform Act was developed based on concerns in that part of the country, but it's being adopted pretty rapidly around the country, which has been interesting to watch. The problem is that when property is distributed to heirs and it goes to multiple heirs, it may end up being divided fairly quickly and to the detriment in two ways. One is that it becomes impossible for one heir to maintain possession of the property, to keep it in the family, and to allow that family to remain in the family home. And this is what we heard about already. The other problem that has also been noticed is that because of the way the partitioning works, an outside developer might buy up one heir's share and then force the partition, and might be able then to buy the property at a price that is significantly below market. And that's been another concern that people looking at this have noticed. And so the family might, in fact, decide that they can't keep the property and be willing to sell it, but then they don't get the value of the property. So what the Act does is a couple things, and the way it's described on the Uniform Law Commission website, it's trying to protect the interests of all the owners. So it's protecting the interests of the heirs, and if somebody does buy one heir's property, it's protecting the interests of that person as well. And so it does, I think, a nice job of balancing. I wasn't involved. I've been aware of this Act for a long time. I wasn't involved in the process of drafting it, but I think it does a really nice job of balancing a lot of interests. And it does that in a couple of ways. It applies if heirs receive property from a relative. So it's really looking at family property that's been inherited by family heirs. So that's one of the requirements. And then it also applies only if there's no written agreement governing the partition. So if all of the kids get together and they agree what to do about the property, they will be able to do that. It's not forcing anything on them if they agree. But if that's not the case, and one of these co-tenants files for a partition order, then a number of things happen. The co-tenant that's requesting the partition has to give notice to the other co-tenants. Importantly, I think the court has to order an independent appraisal to determine the fair market value. And so that's important at a couple of stages, protects the rights of all of the co-tenants. Any of the co-tenants can then, at that point, choose to buy the property. So if one of the other co-tenants wants to keep the property in the family, that co-tenant can buy out the co-tenant who needs to sell, but at fair market value, depending on the number of shares. And there's a process built into the Act for the amount of time that has to be provided in order to give the other co-tenants a chance to arrange for financing and make that happen. But if none of the co-tenants are able to purchase the share, then the court is required to order a partition in kind if that is possible. It may not be possible. If it's one house, it may not be possible to order a partition in kind. And if it's not possible, then the property can be partitioned and sold, but the sale on the market can be at a price no lower than that court-determined fair market value. So it protects the amount of money that the heirs will get, because what the evidence from some other states, I don't know if this is also happening in Portland, but I wouldn't be surprised. What's happened in other states is that there's a partition and then the property ends up being sold at a very discounted value, and that then leaves the heirs with very little from their inheritance. So it solves that problem as well, but it also protects the family, gives the family time to choose to buy out the co-tenant who wants to sell and keep the property in the family, which is great. That's all for me.
Thanks, Susan. Does anyone have questions for Susan? Okay, maybe we'll move on to Angela, if you had something to say about how this is affecting the commissioner's constituents in North and Northwest Portland, or Northeast Portland.
I don't really have much to add besides what the commissioner said. I would mention that this issue has come. It was also an issue that Senator Roebland was contacted. So over on the coast, it's come up. So it's not specifically just Portland. I'd imagine there's other areas that are experiencing this happening.
Thank you for reminding me of that. Yeah. Professor Bates, what's your experience been with this issue?
Yeah, I sit on the oversight committee for the North-Northeast Housing Strategy in Portland, which is the city's attempt to sort of address some of the past harms of urban renewal practices in Northeast that have particularly affected the Black community. I also have spent a good amount of time in partnership with the Portland Housing Center, which is a local home buying organization, in working with them on some of their financial capabilities, financial literacy, and homebuyer education work. And so through both of those spaces, I have encountered, and certainly those organizations and oversight committees have encountered the stories of people where this is exactly how they're losing their homes. So at a time when we're trying to make sure that home ownership is meaningful for people, and that given the market, the sort of gentrification in the market, if there's an opportunity of wealth building, that if there is a sale, that it would happen at market rate. So exactly what Susan just described, we've seen both of those instances, both instances where one heir, sometimes someone who's not necessarily closely connected to the family, even is forcing sale. So those folks who thought that they might have an opportunity to purchase the home or live in the home aren't able to, and certainly seeing those sales happen at below market. So, you know, we know we don't have the home ownership rate for Black folks in Oregon is below the national average, which is already substantially lower than the sort of mainstream homeownership rate, or the overall homeownership rate. And with the pace of market change, not only in Portland but in other communities, I think this kind of stopgap, certainly combined with more education around the probate process, wills, and other kind of financial literacy, I think will be an important tool to at least kind of put a door stopper in some of the processes that are happening kind of almost before families know even what is being talked about.
Thank you. Is there any organized opposition to this kind of bill?
I haven't heard of any. I'm not aware.
We haven't heard. We also have not heard of anything. We have talked with Rhett Sanchez, Rhett Bynum, and Senator Frederick, and they've all expressed interest in it.
Yeah, I think it'd be really important to make sure that we're putting together a diverse work group that really includes representatives from all the underrepresented communities on this.
Susan Graby, are you still on the call?
Hey, Sandy, this is Amy. She had to step off for another meeting, but I'm here. Can I help?
Yeah, I was just curious. We always appreciate our help in finding interested parties and members of work groups in the Bar Association. Amy, do you know of any sections of the bar who are currently either working on this issue or groups who are related to that you and your office have worked with who might be interested in serving in kind of the nuts and bolts capacity of working through the Oregon-specific issues of this Uniform Act?
Off the top of my head, I can't give you specific examples, but I would imagine that they're out there. We have a section that deals with real estate and land use. We have a consumer law section. As you know, we have estate planning and elder law sections that are very active with the Law Commission. So there are certainly groups out there that could connect us to people that we want, that could be helpful.
Great. Thank you.
And are we thinking of this as something that could also potentially be ready by 2021?
I would, this is Susan, I would think so. I think because the Uniform Act is in good shape, and I haven't heard of any disagreements about it, and I know it's being adopted pretty quickly across the country. I think it won't take a lot of work. And as we just heard, there are different sections of the bar that can help with the work group, and we also have a number of people already who've volunteered, which is wonderful. I'm sorry, I think your name is Lisa, but the professor who's on the phone, it would be wonderful to have you involved with this.
I'd be happy to.
It'd be wonderful. The real world experience on this issue, I think, is really important. Any other questions on this one?
Just, I'll make a comment again, capacity-wise. Whenever we have a uniform law that's been well vetted, really what we're looking to do at that point is get Oregon-specific input on all sides. But my experience with several uniform laws at this point is those are a really great starting place, and I'm also confident we have the capacity for a one-year project with this, with the uniform law on an issue that has a significant amount of support.
Great. Thank you so much to all of our visitors. We appreciate your input. You're welcome to stay on the line if you'd like, but we're going to move from detailed discussion of the individual bills to talking about whether or not we want to move these proposals along to the Law Commission and about the logistical and policy concerns associated with them. And I think because it might be easier, I think I might ask us to take up the Electronic Wills Act first, followed by the Partition of Heirs Property Act, and then I think that the last proposal might be a little bit more challenging. Before we take those on, though, I want to talk a little bit about what our criteria are for these. I mean, I know that these projects are difficult, and this is the first time that this program committee configuration has met. Due to some of our recent projects, I think maybe we're going to have a little bit more exposure than we have in the past. At least that's my hope. So we may have the fortunate or unfortunate problem of having to worry about capacity. So, Sandy, I know we had talked about having, the tradition, and I think it's a good one, is to keep one member of the commission chairing each work group. We have a couple of work groups that are already going, and I'm wondering if you can give us, I know I'm putting you on the spot for this, but sort of a rundown of, we have some people involved with different things. How much unused commissioner capacity do we have at this point?
Well, we also have 2 vacancies on the commission currently. Both are statutorily members or former members of the Oregon House of Representatives, which creates some challenges. Those were Lane Chatterley's position, and then also now Representative Williamson's position, because she is no longer a member of the legislature. Where we are right now is we have our ongoing projects are the following. We have our LLC group, which is a wonderful group that is taking on a very large piece of legislation that we have a goal of 21, but the reality is that may be a 2023 project. We had a great meeting last week with Legislative Council. They have actually agreed to our proposal of completely replacing that act, which does create some additional work that also may push it for 2 years. The leadership of that group is okay with pushing that to 23. That's going to be an ongoing project, but I don't know if but that's not one we're rushing.
And John is chairing that.
John DiLorenzo is chairing that group with very, very strong partnership with the Bar Association. Again, that's going to be a big project, but not a rushed project. We have the e-notary group, which has a complete bill that's ready to go, but that will still take some capacity in the 21 session to get passed. But that's a relatively non-controversial bill. Most importantly with that one, that is support from everyone we've spoken with, including all of the business-related lobbying groups. So that bill, I would say, is almost assured to pass based off the feedback I've gotten.
Mark has that one.
That's Mark Comstock is the chair of that group. We have two groups that are in the beginning phases. One of them is the next step in the Direct Criminal Appeals project, which Justice Duncan and Krista Obold-Eshelman are leading. Right now, we're still working on completing membership of that group and studying issues, though I think we have a pretty good idea of the issues at this point, thanks to some work that the chairs have done. I'm working with our office, with Debbie back in Eugene, to compile membership. Pretty good luck so far, and I'm feeling really good about first meeting that group in the next couple months. No timeline has been set on a prospective bill there, but that really just depends on what the group feels once we get started. We have the e-hearsay project, which Keith is leading up, but that is currently in a study phase. The Oregon Law Commission's fellows are working on a white paper / memo type document which will outline those issues, but that work group won't even potentially get started until the spring, because the commission the fellows who I'm working with are doing a great job, and they have a goal and an assignment to have that complete by the end of their term, which is in April or early May. I feel like we're going to have that, but that's not and that's going to be a unique project for us as well, because it does deal with sections of the evidence code, and there is no possible way that will be a 21 project. So I think that one will push out. So those are our active projects right now. I think that at the commission's, a little bit of background on capacity issues of the commission's history. The commission has taken on, in certain parts of its history, a great deal of legislation, but that was when it was based here at Willamette University with a pretty significant infrastructure. At one point, they actually had 4 full-time staff members, including a director, a faculty member in support, and 2 support staff. At UO, we have me, and we have a part-time support staff, as well as funding for some student work as fellows. But that's kind of what we have. Even at its peak, when it had the full-time members, and that actually, for a while, actually included an in-house general counsel, which is something we've requested a couple subsequent times but have never received from the legislature. They were at that point working on 7 or 8 bills at once. At the times where it's been more limited in staff, I think we'd be stretched at 4 or 5. I think where we currently are, with the exception, is I have learned that these uniform law projects where a bill is in place, while they do take some legwork, do have a lot less intensity, just the overall logistics and planning and getting them passed. It doesn't mean that, there's still a lot of meetings I need to go to and make sure the paperwork's done and making sure the legislature is aware of it, but I'm confident with those projects that we're in pretty good shape. So we have e-wills, we have the notary project, and we have the Partition of Various Property Act would all be based off uniform laws. So I think that would help allow for us to have more significant capacity, but that's kind of a big picture of where we currently stand with the commission.
There's one other project we haven't talked about as well, which is the collaborative law
That's
project.
true, yes.
So the commission has already accepted the project on collaborative law, but it's been sort of sitting there for a couple of years.
And we still don't have a chair.
We don't have a chair. I'd like to discuss that with this group, because I think it's the appropriate group to bring it up. That seems to have been kind of an orphan project with no commissioner who is really willing to step up to do it. I have been toying with the idea of suggesting to this group or to the larger commission that we, for lack of a better term, dismiss review as improvidently granted on that one. I mean, it's not a good look to have us sitting on a project for such a long time. And if we're never really going to move with it, and if no one's willing to take ownership of it, I kind of feel like we need to be straightforward about the fact that we're not moving on with it, so that other people will know that that's a project that can move on. With that in mind, I think it might be worth having a little discussion as well about what our criteria are for actually accepting these projects, right? We've talked about capacity. I think that has to be one criteria, but I think that, you know, historically, the purpose of the Law Commission, and correct me if I'm wrong, Sandy, has been to take up things that really required a diverse group of stakeholders to be brought together that might not be able to be brought together through other kinds of auspices, and to have that what Shannon was talking about, that level of credibility and at least faith in the process, that it's open and inclusive, but also that the projects be of a complexity that probably
technical expertise,
right, would need to be taken on by this kind of group. I am also personally interested in trying to have us pursue projects that are going to aid underserved populations, and of course just the general efficiency of the system altogether. I don't think there's any point in taking on some esoteric issue if it's something that people either have the power to do so on their own, separately, or that it really doesn't inure any particular benefit to the system. That's just my particular bias. I wonder if there are other criteria that folks think we ought to be considering as we look at these projects.
This is not I don't know if this counts as a criteria, but I think we would want to, and I think we probably would, give a closer look to uniform law acts. I'm not a uniform law commissioner, but I do have a lot of respect for the work that they do. They put together diverse work groups. They try to involve all the stakeholders necessary. So by the time an act gets through their process, it's received a lot of attention and thought from a lot of different people. And that's not enough to say if it doesn't meet some of our other criteria, there might be an act that would come through that we go, no, we don't need that. But I think that would be one thing we would want to look at. It means that other people think it's important.
One thing to note is our charge is actually dictated by statute in its ORS 173.338 under Law Revision Program. Just as a citation, actually 173 in Chapter 173 in general is actually the Oregon Law Commission's chapter, but 338 actually gives us a pretty clear sense of where how it specifically says the Law Revision Program conducted by the Oregon Law Commission may include but is not limited to, and then it lists A, B, C, D, E, and then it shall study any topic that the Legislative Assembly by law or concurrent resolution refers to the Commission. So one note that's related to that, and I think in this case it only relates to the custodial parent project, is this has been referred to us. We can define study any way we like, but directly from the Legislative Assembly. The others are not specifically from the Legislative Assembly.
Does it say that we shall?
It does say shall. It says shall study any topic. It does not say that we need to take it up and form a work group, but it says we shall study. And just some other highlights of our charge from the statute. Review of common law and statutes of the state, current judicial decisions for purpose of discovering defects and anachronisms in the law, and that's an area they've done in the past. Consideration of changes in the law and this very specifically ties us into uniform laws, and that was part of the original creation of this commission. From the American Law Institute, the National Conference of Commissioners on Uniform State Laws, any bar association, and other learned bodies is actually the term it uses. Consideration of suggestions from judges, justices, public officials, lawyers, and the public. That fits very clearly in our Uniform Partition of Harris Property Act. That does come from public officials. Recommendation for for changes in the law that the Commission considers necessary to modify or eliminate antiquated or inequitable rules of law, and to bring law of Oregon into harmony with modern conditions. That very clearly relates to our E projects. And then recommendation for the express repeal of statutes repealed by implication or held unconstitutional by state or federal courts. That's not something that our group's been asked to do very often, but it is a statutorily allowed function of our group. So that's just that is the statute that dictates what our bounds, what we're able to do, are by Oregon law.
Very helpful. So with that in mind, I think I'll start by having us talk about the Uniform Electronic Wills Act. Does anyone have any further discussion on that, or wants to make a motion for us to recommend to the full commission that we take it up? That's how it would work, right?
Yeah, and just one quick note before we do that. Judge Egan, just to clarify, you're actually not a member of the program committee, so I just want to make sure that you're aware of the voting membership who will be able to vote currently. I appreciate that you're here, and are Keith Benovich, Professor Susan Gary, Justice Duncan, and PK.
But if you want to commit to coming all the time, we can make you a member.
Come when I can.
We really appreciate you being here, but I just want to make that clear for voting purposes. But yes, to make a motion and then have it voted on with the majority sending it to the full commission, and or not.
Okay, great.
This is Keith, and
All right,
I would so move.
Okay, so do we have a second?
Second.
Okay, so it's been moved and seconded that we recommend to the full commission that we accept the proposal on the Uniform Electronic Wills Act. Is there any further discussion on this issue? Okay, hearing none, I'll call for a vote. All those in favor say aye. Aye.
Aye.
Any opposed? And any abstentions? Okay, that motion passes. I will now take up the Uniform Partition of Heirs Property Act. Do I hear a motion on that issue?
I move the committee, I should just say so moved. That's easier. I move the committee vote to send this to the full commission.
Excellent. Do I hear a second?
Yeah.
Okay. Hearing a motion and a second, is there any further discussion on this proposal?
I think I would just say, I think this really does seem to fit our group's load, and it's an important issue that we need to take, that we can take timely action. Sounds like we have from law and support of folks across the state.
I'm really excited about this project, actually, and I'm not even knowing about this problem. When it was brought to me, I was astonished, and also really happy that we can do something to elevate the issue. So I'm in favor of it as well. Any further discussion? Okay, hearing none, we'll move to a vote. All those in favor of moving this proposal to the full commission, say aye.
Aye.
Any opposed? And are there any abstentions? All right, that motion passes as well. So now I'm going to move us to the proposal about custody and allocation of parental decision-making. Is there any discussion or motion on this issue?
I will move that we vote to approve that the commission appoint a work group, appoint a work group to continue the work on this project.
Do I hear a second on that? Perhaps this is worthy of further discussion?
This is Keith. My perspective on it is that it certainly is a valuable project. It is something that clearly needs to be explored. The difficulty I have is that having just approved 2 projects, and we have a number of projects that are already in line, I'm not eager for the Oregon Law Commission to step into this area when there are already people that have been wrestling with the issue, and our time is limited. So it's really, in part, a resources question And the scope of the project, to me, seemed fairly broad, and hence my reluctance to move it forward.
This is Becky. Duncan, I share Keith's perspective on that. I do think this is an important issue, but there is a group that forwarded the changes to the domestic relations statute. It seems like that group, well, there is a need for assistance if that's the way they want to implement the change. It has such ramifications throughout the code. On the one hand, it seems like we're doing a little bit of just drafting work, but on the other hand, that drafting work will give rise to an unknown number of policy issues that could be quite resource intensive. Without a better understanding of what policy questions will arise, I'm hesitant to recommend that the commission take this on at this point.
I have concerns about this one as well, for a lot of the reasons that you have just stated. I'm also concerned, though, about our statutory charge and our need to maintain a positive relationship with the Judiciary Committee. And so that's, really why I'm torn on it. I wonder if there is some way that we could send this back with a request that they do a better job of defining what it is that they want us to do. Because I feel like maybe there is some value that we could add there, but I am also daunted by the scope of what they're talking about.
I could suggest a couple options that the group could do rather than form a work group immediately pointing towards creating a bill. We could put it in the category which we've been doing for a couple of years now, and now we actually have movement on it with the e-hearsay project, which Keith was actually the proposer, would be to have it be a part of further study, and that is actually the language of the statute. It's something that it would be after their work on the e-hearsay project, but I could have, if the commission felt it was a valuable project for them to do so, I could have the fellows at the University of Oregon School of Law look further into the statutes to see what type of, in correspondence with the legislature, to get a more precise view of what the charge would be. That was the idea. That was the thought process behind having them work on the e-hearsay project first, because it was very broad, and we really wanted to have something more concrete before we would take that time and ask other legal professionals who are extraordinarily busy to spend time on that. Also, we have a great working relationship with the Judiciary Committee. I don't believe that not taking on at this time, from my understanding, would harm that, as long as we did continue the collaboration and communication. One thing we could do is table a proposal at this time, not reject it, and continue to work with the Judiciary Committee on the issues that have been, the concerns that have been brought up. That could be along with studying the proposal. We also could, and I need to speak with some people who know more history of the Law Commission, but the Law Commission over time has actually appointed, excuse me if I get the label wrong, but study groups rather than work groups, which are a smaller subset of legal professionals who are willing to put the time in to create a document which further specifies the charge. I know that when it was based here at Willamette, there were several of those. Some were related to ongoing projects, but some were not. I have binders, actually, of projects which never moved forward ever, actually, with a formal proposal, a formal bill. So that would not be out of character with the Commission either. So any of those would be appropriate for the Commission to take on.
I'm thinking of something like, I know that Jana has that list of, where it comes up, but if we had someone do the initial legwork of looking further into what those things mean and what the potential policy issues are that are implicated by each of those kinds of references, so that we'd know, Becky, you're talking about, we don't know if this goes into workers' comp or if this goes who knows where. It would be helpful to have more of an idea of what that scope looks like, and then maybe some of those things are more obvious, and that the folks who are looking at that will have a simple solution for them, and then maybe there are some that are more complicated, and those are the ones that maybe it's worthwhile bringing a work group together to drill into.
So my understanding is if we were going to take any of those suggestions I brought up, there's no formal action that would need to be taken by this group, other than it will certainly become an agenda item for the full commission. It can be discussed by this work group, but I don't believe, other than actually passing a work group itself to be moved forward, I don't believe there's anything that's part of the formal program committee's charge. So I know we want to talk about that because there's actually not a whole lot written about the program committee's charge in the past, other than passing, reviewing, and sending forward proposals to the actual law commission.
Right. I wonder if this is a discussion that might be worth having, you know, rather than triangulating between us and Judiciary and LC, maybe it's worth having a discussion, Sandy, with Dexter.
Sure.
To see what he sees the issues are here, and if he's concerned about there being, you know, policy issues that LC doesn't want to take on in terms of the drafting, maybe they could do the legwork of figuring out what those issues are, even if they don't want to make a decision on them. I mean, that would at least tee it up further than it is now. Okay, I've spoken enough. Anyone else have other thoughts on this? Jim?
I have thoughts about the commission itself. You have a limiting charge, but there are clearly enough projects out there for you to handle. Are we considering, or are you considering a policy option package or anything? The legislature, they're charging you to do the work.
So we have proposed the policy option package at the last two full sessions. They've both been rejected. We're facing a more immediate concern, which we'll discuss at the next commission meeting, about actually funding the core mission of the commission moving forward to the 21 session. Because of the move the commission made to the University of Oregon School of Law, we are now bound to employing public employees rather than employees at Willamette University, which adds a significant amount of money to that overall package because of pension and healthcare benefits through the state. So we're going to have to make a decision as a commission whether or not it makes sense to request a further policy option package for a staff attorney, which is what Lane had always...
That's the obvious move.
Right, it always thought would be the most logical addition to the commission, when we're going to need to ask for close to another $100,000 simply to keep the commission alive at UO.
Yes, and it's a good point. You know, when we did the most, other than the LLC one and the probate one, the most recent one that was on a short timeline that took up a lot of time was
the legislature.
Yes,
very
much. As a harassment issue.
and they provided us with a full-time staffer.
They did.
To help with that, you know, and I could see this being a project that could use a full-time staffer, so.
That's a good point, though. If I would go back to Dexter with legislative counsel, and they would want to provide a full-time staffer, we could always reconsider.
Mm-hmm. I always like using any leverage that we can with the legislature to help them understand our fiscal bind.
The policy option package has the advantage of creating a permanent budgetary presence that will allow us to continue to do the work that everybody knows needs to continue, and that the legislature is tasking you all.
So in 21, I appreciate, we are still a part of the OJD budget, which is interesting, but that is where we are.
I didn't know you were part of the OJD budget, and that leads to the follow-up question. Is the OLI part of the Oregon Judicial Department? What's our new, sort of mission statement / ongoing, if whatever policy option packages are proposed under the OJD budget have to be part of the OJD's sort of vision for the future mission statement that was recently published. So, got to think about that. Okay.
I don't think that there's ever been a very obvious place for where to slot the Law Commission.
Well, you're kind of like the Oregon Judicial Fitness Commission. Right?
Yeah.
There's this executive director spot. The budget is like, the commission had to go back every time they had a trial and every time they had something asked from the e-board.
So, yeah, and we'll talk about budget issues. It'll be a prime topic at our next commission meeting, because yeah.
Good times.
Yeah,
Good times.
Okay.
Well, I think that we've covered a lot today, and it sounds like the general consensus about this last proposal is that it just needs more study and more discussion, and so we won't take up a particular motion on it today.
I'll follow back up with Shannon.
Thank you.
But if technically, wouldn't you do a motion to table and then?
That's what I would suggest.
Do that?
Yeah.
Okay. Someone want to make a motion to table?
Okay.
Do I have a second?
Second.
Keith.
Yes.
Thank you, Keith. Any further discussion on the motion? Okay, hearing none, I'll take a vote on the motion to table. All those in favor, say aye. Aye. Aye.
Aye.
All those opposed? And any abstentions? That motion carries. Thank you. So I think at our next program committee meeting, whenever that may be, I think it's worth having a more detailed discussion about criteria and capacity and that kind of thing, but I think it was good to prime the pump on those issues today so that we can all be thinking about those. We also do have at least one spot on the program committee
Yeah.
that is currently
That's
vacant.
correct. We have one spot that's vacant.
That we're working on, so we may have an additional person here next time. Okay. Anything else for the good of the order? All right.
Thank you all for being here today.
Yeah, thank you.
And thank you for those on the phone, and you will hear from me soon about scheduling the next commission meeting, hopefully in late February or early March.
Thanks, everyone.
Thank you.
Thanks, everybody.
Thank
For
you.
the record, we're out of here 5 minutes early. Thanks, everyone.
Yeah? Basketball season over?
No.
You're in the middle of it?
Yeah,